So the Internet Archive, known primarily for their efforts with respect to the Wayback Machine, suffered a devastating loss in court earlier in March with respect to 4 book publishers that filed suit against Internet Archive alleging copyright infringement. We're going to go ahead and dive into the details of this case to get a better understanding of why the Internet Archive brought forth a case that ultimately failed here on The Breakdown. Hey, this is Hoyt from The Breakdown. If you're new here and checking out the channel on YouTube, go ahead and hit that subscribe button. Also, feel free to follow me on Twitter at GregHoytLET. Anyway, let's get on to the video. So on March 24th, the U.S. District Court out of New York's Southern District sided with the plaintiffs, them being 4 book publishers, with respect to an ongoing lawsuit between these publishers and Internet Archive, with the court finding in their summary judgment that Internet Archive did, in fact, violate the interests of the copyright holders, them being the 4 book publishers, with respect to Internet Archive's endeavors with this sort of online digital library that they've been engaged in for a number of years. So, to give a little bit of brief context on the matter, the Internet Archive, for a number of years, was engaged in what they called a sort of digital library, where the Internet Archive had legally obtained copies of physical books, whether they got them secondhand, direct from publisher, warehousing, whatever. They had legally obtained books, physical copies of them, and what they were doing for a number of years was scanning those books in their entirety and then creating a sort of digital library where, for a number of years, they would lend out a single digital copy of the book that they owned a physical copy of. And, those efforts went pretty much unnoticed, or, copyright holders, book publishers, didn't really give too much of a care, or at least, again, they may not have even noticed what Internet Archive was doing with their digital library. Essentially, anyone with a working email address were able to give their email to Internet Archive to become, a library patron, authorized to check out a book. And if they had one physical copy of a book, then they would lend out one digital copy of the book. And, individuals who were borrowing that copy, which it was an encrypted file where it couldn't be downloaded or anything like that, they'd keep it for 14 days, and they would give it back to the Internet Archive, and then Internet Archive would be able to lend that book out again, so on and so forth. But around March of 2020, the Internet Archive managed to gain some newfound attention, which that attention ultimately didn't behoove them, because in an effort to behoove people who were staying home and saving lives in March of 2020, the Internet Archive decided to abandon their one-for-one digital lending practice, and instead were allowing individuals to check out any number of books regardless of how many copies they had of it. Say, for instance, they had like one physical copy of an Anne Rice book or something like that. They would allow, during the period of March 2020 up through June of 2020, they would allow up to 10,000 people to borrow, check out a digital version of that book at the same time. Now, the 4 publishers in question, they brought suit against the Internet Archive in June of 2020, and it's probably because they caught wind of this massive digital library where the copyrighted works were able to be disseminated at scales, way beyond what the Internet Archive had in physical possession. Thus, these 4 publishers, who respectively held thousands of copyrighted works that were being disseminated through Internet Archive's digital library practices, they filed suit and said, hey, this looks an awful lot like, copyright infringement, among other things. Whereas Internet Archive was bringing arguments claiming, hey, what we're doing, it's actually not copyright infringement. What we're engaged in is fair use. Obviously, based upon the outcome of the summary judgment, the Southern District of New York found that, no, what Internet Archive was engaged in was far from fair use. So let's go ahead and dive in to the arguments brought forth by Internet Archive, and we'll see how the court responded to them. So one of the fair use aspects that the Internet Archive was leaning on with regard to their argument about this activity of theirs being an act of fair use is the first sale doctrine. According to the summary judgment, the first sale doctrine is codified at 17 U.S.C. 109A. The doctrine provides that a rights holder's control over the distribution of any particular copy or phonorecord that was lawfully made effectively terminates when that copy or phonorecord is distributed to its first recipient. However, as noted later on in the same summary judgment, Section 109A does not excuse Internet Archive's unauthorized reproduction of the works in suit. The court was basically saying that the first sale doctrine relates to the tangible item that you initially bought. In this case, it would be the physical book that Internet Archive legally acquired, and that the first sale doctrine does not afford any wiggle room for an individual to reproduce the individual item they bought legally and then distribute at scale the copies that they made, which the Internet Archive was admittedly doing this between the months of March and June of 2020. So let's go ahead and dive into one of the more contentious aspects of this case, namely the NEL library conundrum that Internet Archive launched in March of 2020. Say a Blockbuster Video had purchased a single copy of Terminator 2 on VHS back in the 90s, but decided to take that one single copy and make 50 copies available to rent out at any given time. Internet Archive basically did the same thing during the NEL period of 2020, except they effectively made 10,000 copies to distribute of each copyrighted work. Now, another area that Internet Archive was leaning on with respect to their claims of fair use for their digital library endeavors was that somehow their work or their efforts with the digital library was essentially transformative in nature, which the March 24th summary judgment does make reference to what transformative use of copyrighted material is, noting a transformative use adds something new with a further purpose or different character, altering the first with new expression, meaning, or message, rather than merely superseding the original work. Yet the court found that what the Internet Archive was doing with respect to its digital library was far from transformative, but rather derivative of the copyrighted materials, noting in the decision, Internet Archive simply scans the works in suit to become ebooks and lends them to users of its website for free. But a copyright holder holds the exclusive right to prepare, display, and distribute derivative works based on the copyrighted works. Here's a little bit more context as to what the court is referring to with a derivative work in this particular case. So let's go ahead and dive into what a derivative work is. Say, for example, Blockbuster Video had decided to convert all their legally acquired VHS movies and convert them into more updated formats like DVD or Blu-ray so as to rent out the titles in the new format. That would be considered a derivative work, even though Blockbuster legally acquired the original VHS tapes and were thus authorized to lend, rent, or resell the legally acquired copies. They wouldn't be authorized to make a derivative work of the legally obtained copies to engage in the aforesaid acts of lending, renting, or reselling. And Internet Archive was found to be doing exactly that. The legal arguments brought forth and the past cases cited by the Internet Archive in their defense and assertion of fair use was pretty bad. One prime example of the Internet Archive bringing forth a really bad legal argument and bad case citation in their effort to claim fair use was their usage of the 1984 case of Sony v. Universal, where they tried to claim that what they were doing was essentially the same as selling VCRs and Betamax players. According to the summary judgment, it reads, Internet Archive relies heavily on Sony. Sony was accused of contributory copyright infringement based on its sale of Betamax machines to customers who could then copy programs to be viewed at a later time, even though the customers could have viewed the programs for free when they were broadcast. Internet Archive is not comparable to the parties in Sony, either to Sony, the alleged contributory copyright infringer, or to the home viewers who use the Betamax machine for the non-commercial, non-profit activity of watching television programs at home. Unlike Sony, which only sold the machines, Internet Archive scans a massive number of copies of books and makes them available to patrons rather than purchasing ebook licenses from the publishers. Internet Archive is also unlike the home viewers in Sony who engaged in the non-commercial, non-profit activity of viewing at a more convenient time television programs that they had the right to view for free at the time they were originally broadcast. The home viewers were not accused of making their television programs available to the general public. Although Internet Archive has the right to lend print books it lawfully acquired, it does not have the right to scan those books and lend digital copies en masse. In another example of a really poor argument brought forth by Internet Archive in this particular case was their claim that they should have been allowed to do what they were doing because a lot of the books that they published were over 5 years old. As noted in the summary judgment, Internet Archive argues that because most of the works in the suit were published more than 5 years before Internet Archive copied them, Internet Archive has not interfered with the author's right to control the first public appearance of their expression, which the court in their decision pointed out that published works do not lose copyright protection after 5 years. But it seems like one of the biggest pet peeves associated with these 4 publishers that brought suit against Internet Archive wasn't just the mere act of, the derivative works, the outright copyright infringement, but they also alleged that Internet Archive's exploits basically stepped on their toes monetarily because these publishers in question offer digital versions of their books, which they sell and license to individuals, libraries, and so on and so forth, which the 4 publishers clearly argued effectively in this case, that the digital books that they sell and they license were being upended by the bootlegs, for lack of a better term, that Internet Archive was making and disseminating for free. So again, this is a summary judgment, and all a summary judgment is the plaintiff and defendant in a case avoiding a trial and a judgment being made as to who is correct in the matter, whether it be the plaintiff or the defendant. Obviously, in this case, the 4 publishers were found to be the winner of the case. Now, people may be wondering whether this is going to be like the end of the Internet Archive, and that's really hard to tell because it's unclear exactly what kind of judgment in terms of monetary or anything of that nature would come forth. Now, for the sake of context, the Internet Archive did bring forth an argument, albeit prematurely because it's not ready to be discussed yet, but the Internet Archive did bring forth the argument that since they are a non-profit and they thought they were doing something legal with respect to copyright infringement, that they should not be held to any monetary punishments with respect to copyright infringement. But the judge pointed out in this decision that, Internet Archive was arguing that a little bit too early, but they are free to file that motion when it is appropriate. Anyways, guys, that's pretty much the long and short of it. Obviously, this decision that came out from the Southern District of New York, it's 47 pages long, and it has a lot more information if you really want to get into the nitty-gritty of all the things that were examined by the court and the arguments brought forth by the Internet Archive, arguments brought forth by the publishers, so on and so forth. I'll go ahead and leave a link in the description if you want to go ahead and browse through that 47 pages. But again, these were some of the key elements that really led to the Internet Archive losing this legal battle. Nonetheless, go ahead and share your thoughts on the case. Drop your comments below whether you think that the Internet Archive should have won, whether you think the court made the proper decision. Whatever your thoughts on the case, drop a comment below. That was the breakdown. Peace.